There are many aspects of our legal system that most of us do not question. We obtain our licenses, we are aware that laws apply to us, we're respectful of judges in the judicial system, and we definitely do not threaten our judicial officers. However, there is a growing ideology that questions all of this: sovereign citizens. Courts across Australia are increasingly deal with arguments by people who claim to be sovereign citizens, arguing that the government's laws and regulations do not apply to them, and that the Commonwealth of Australia is not a legitimate state. The people making such arguments often identify as sovereign citizens, free men, living men and women, constitutionalists, or other similar labels. And today we're unpacking who sovereign citizens are, where the movement came from, what sovereign citizens believe, and why courts across Australia consistently reject the legal arguments put forward by them.
Thanks, Julie. Yeah, so I guess the natural question is, what is a sovereign citizen? So sovereign citizens are people who believe government authority over them is illegitimate or limited. So laws do not apply to them. So while we are focusing on sovereign citizens in Australia, they are present all over the world, particularly in common law countries that operate on English common law, with similar movements emerging throughout the world. So sovereign citizen movements is an ideology or a loose group of people, such as individuals connected by their anti-government stance who claim that they are not bound by Australian law and try to evade legal requirements, including paying taxes, paying fines, and attending jury duty. So whilst most sovereign citizens hold similar views, there isn't one set ideology. It's more of a self-identification than a membership to a specific group. So what unites them is that they believe that courts of law and authority have no jurisdiction over them, and that they can somehow opt out of obeying laws, paying taxes, ignoring court decisions, ignoring licensing requirements, or disobeying government authorities through particular legal arguments, documents, or declarations. So essentially, it's based on a pseudo-legal argument that are fabricated and misguided in interpretation of fundamental laws. And we'll flesh out this in more detail throughout this podcast. We understand who they are, but what's the history behind it?
So the sovereign citizens definitely blew up and started getting a lot of attention around the time of COVID and more recently. But it's not a new or emerging concept, and it did not appear overnight. In fact, it could be traced back in history as early as the 1950s and 60s in America and the 1970s in Australia, with Leonard Casley, a wheat farmer from Western Australia, founding a self-proclaimed micronation of Hutt River Province in Western Australia, where he created his own government and tax system. Or even later, in 1983, when Alan Skyring objected to paying income tax on the basis that the Income Tax Assessment Act was invalid as it contravened the Magna Carta. He later was declared a vexatious litigant in 1992 and became bankrupt soon after. Sovereign citizens continued to exist within society, and in 2015, they were identified as a potential terrorist threat by New South Wales Police, New South Wales Counter-Terrorism and Special Tactics Command, which estimated as many as 300 sovereign citizens living in New South Wales. As we said, the movement gained real traction in Australia and became more publicly visible in 2020 with the onset of COVID-19, when it began to overlap with anti-vaccination, anti-COVID and anti-lockdown movements. Lydia Khalil, a research fellow at the Lowy Institute, observed during the pandemic the sovereign citizen movement intersected with these groups and attracted and interacted with a number of far-right and extremist elements that sought to find a common cause and recruited among the sovereign citizens' anti-vax and anti-lockdown cohort. With the use of technology during COVID, the movement grew as sovereign citizens connected globally, where distrust of government institutions, public health measures, and authority generally created fertile ground for sovereign citizen ideas. So Finn, have you had any experience with sovereign citizens?
Yeah, so generally the movement claims to be non-violent or that they act in self-defense against authority. So however, in recent times, the sovereign citizen movement has brought to light an element of violence, which could be said to have originated in the US with the Waco siege and the Oklahoma City bombings. We focus on the movement in Australia, and most recent violent notions within the movement, such as Desi Freeman, who identified as a sovereign citizen and subscribes to an anti-authority ideology. Freeman gunned down 2 police officers who were visiting the property to execute a search warrant. Following this, Freeman evaded police for some 7 months, and it is claimed that he was protected by those linked to the sovereign citizen movement. So while sovereign citizens believe that they are morally and legally correct, the movement can be considered a roadblock for the existence of a cohesive and safe society in which individuals follow the laws and are active participants of important government systems and are also held accountable under such laws and systems. So The movement preys on vulnerable subgroups within society, one example being those who are unable to make ends meet or make false or illegal promises, such as the evasion of tax, to increase their numbers. Moreover, the sovereign citizens within our society have placed a major strain on judicial systems, with research in South Australia by Joe McIntyre indicating the judgment time for court matters has increased by 50% due to litigious efforts of sovereign citizens. McIntyre found that not only were there sovereign citizens clogging up the court systems, but they have also posed such a threat to judicial officers that the court created an ad hoc register of regular sovereign citizen litigants to ensure there were additional supports and security for when they were in court. The Lowy Centre reported that nearly a quarter of judges in New South Wales have received death threats, with a disproportionate amount coming from sovereign citizens. These tactics are not new to the movement. In 1997, John Wilson, a sovereign citizen, was held in contempt of court when he threw multiple paint bombs at a judge and his staff when an unfavourable judgment was handed down in the Supreme Court. Yeah, I worked in the courts recently, and there were a number of sovereign citizens, and even for mundane court appearances, they do definitely take up some time, which really flows on to more complex matters, which is unfortunate.
Yeah, it's definitely a problem for not only the people who are working in the courts, but for people, waiting for their turn to have their matters heard. Exactly, you said that flow-on bottleneck effect. So we've kind of covered now how they're acting in court, but we also want to go through what they're actually doing, some of the legal arguments they're making and their belief systems, and also debunking them and kind of explaining, why they don't work. Not why they don't work. Kind of debunking them and explaining, why they don't stand and are regularly rejected by the courts. So as we've established, the sovereign citizens is not an entirely uniform belief system. There's a general shared baseline of extreme anti-authoritarianism and this belief that the Australian government and its laws are illegitimate and therefore that they do not have to comply with them. Even when it comes to this belief of the illegitimacy of the Australian government, different groups and individuals within the sovereign citizen movement have different bases for these arguments. So some believe that Australia was a country but became a corporation in the 1970s, which we'll cover. And now it's no longer a country. Others believe, that paperwork was done incorrectly all the way back at Federation and therefore it was never a legitimate country. Others go even further back, relying on older documents such as Magna Carta or, other countries' Bill of Rights as, a basis for law, saying that, none of this was ever legitimate. Let's go through some of the arguments that they're making in court. So first, as I flagged, is that they claim Australia is a corporation and not a sovereign state. However, Australia naturally is a corporate state and it's not a corporation. The source of this misconception is based on Australia being registered on the United States Securities and Exchange Commission, the SEC. The actual reason it was registered is so that the Australian government can sell securities in the US markets, which other countries are also registered on the same market. Another example of this is from the state of Queensland. So there's a misconception relying on the registration of the Brigalow Corporation, which they claim is the corporation that owns Queensland rather than the Queensland government. In fact, the Brigalow Corporation was a corporate entity created by the Queensland government in 1992 for the purpose of overseeing the Brigalow Lands Development Scheme, and the chief executive of Departments of Lands was the sole person who comprised this corporation. So, following their logic, if Australia was a corporation, not a state, it could be argued that it doesn't have sovereignty and therefore doesn't have the rights to make laws. But as we've said, Australia is obviously not a corporation. It's a state or a government that has registered corporations. The second major pseudo-legal argument that they rely upon is that all governance and interactions with officials are based on consent, and that if you refuse to consent, you are not required to follow Australian law. This is based on contract law. You cannot have a contract in Australian law, or most legal systems, unless both parties agree to the contract. This can be explicit, like signing a contract, or implied, like purchasing certain products. However, laws are not based on consent. Laws are imposed on you whether or not you like or agree with them. This logic of consent in the contractual relationship likely ties back to this idea of Australia as a corporation and not a governing entity. This also explains why sovereign citizens resist in so many aspects of civil society and the judicial system. Getting a driver's license, registering your vehicle, signing court documents, they're all seen as entering into contractual court documents and into contractual agreements that they then believe would make the law apply to them. And they believe by not doing this that therefore, traffic offences and driving laws and all these things don't apply. Some sovereign citizens even believe answering questions from a police or a judge creates a contractual relationship in which they will now be governed by these laws. So, for example, if they're asked, do you understand, by a police officer or judge, let's say when being told to comply with an order or, given instructions, they see saying yes as consenting to that law, order, or person having authority over them. So I've seen one explanation even that it's do you understand is code for do you stand under our law? Therefore, they'll refuse to answer or be purposefully evasive in response to what seems like a simple question, which explains a lot of those videos you might have seen of them getting pulled over by police or just, the baseline refusal to engage. So as a result, they often refuse to sign documents, acknowledge authority, or even answer questions because they believe they're preserving their sovereignty by doing so. Obviously, none of this is true. There are no secret codes or being tricked into surrendering your rights, and laws are not optional to engage with.
I find it so interesting, the pseudo-legal nature of their arguments, particularly those first two. But this third argument we'll look at, which is the living man versus straw man theory, is one of the most foundational sovereign citizen beliefs. So according to this theory, every person has two identities, a natural person and a legal person. The natural person is flesh and blood is a flesh and blood human being, the free man. The legal person, often called the straw man, is supposedly created when a birth certificate is issued. Depending on which sovereign citizen you ask, the birth certificate either turns you into an asset of the government, corporation, or creates a separate legal entity that the government controls. So in their view, laws apply only to the straw man, not to the living person. They often point to things like names being written in all capital letters on official documents as proof that the legal system is dealing with the straw man rather than the real individual. Definitely not because of administrative formatting, poor handwriting, or the fact that capital I looks suspiciously like a lowercase l. Because of this, sovereign citizens claim that they separate themselves from their legal identity, declare themselves living men or women, and place themselves outside the reach of legal systems. This is why you'll often see them using unusual aliases or writing their names with unconventional punctuation or formatting. The idea is that they are refusing to identify the strawman. If any of this sounds remotely convincing, the courts have been very clear it doesn't work. As we've already discussed, Australia is not a corporation, and a birth certificate is not some kind of contractual registration into a separate legal entity. A birth certificate simply records a birth. It does not create a legal personhood. A baby is legally protected before a birth certificate is issued, and a person's legal rights and obligations do not depend on whether a certificate has been produced. Australian courts have repeatedly rejected arguments that identify as a freeman, refusing to state your name or denying the existence of your strawman changes your legal status. The law still applies. This thinking also spills over into contract-related arguments. Sovereign citizens often refuse to sign bail undertakings, court documents, or other official forms because they believe doing so creates a contract with the government. Unsurprisingly, courts have not accepted this argument either.
The final major pseudo-legal argument that we'll be covering is that there is an alleged right to a trial by jury in any case under Clause 39 of the Magna Carta. The Magna Carta was a landmark English document sealed in 1215. Its significance lies in establishing the principle that even rulers are subject to the law. While enormously influential in the development of legal systems, it's not a winning card that overrides modern Australian legislation. So Clause 39 specifically provides that no free man shall be seized or imprisoned except by the lawful judgment of his equals or by the law of the land. Sovereign citizens often argue that this clause guarantees a right to a jury trial in any legal proceeding, and that any Australian law inconsistent with their interpretation of the Magna Carta is invalid. Australian courts have repeatedly rejected this position. The right to a jury trial depends on the relevant legislation, the type of case, and the court hearing it. There is no universal right to demand a jury for every proceeding simply by invoking the Magna Carta. As you might expect, sovereign citizens are frequently self-represented or represented by like-minded supporters. Hearings can turn into lengthy performances involving pseudo-legal arguments, repeated challenges to the court's authorities, and frequent interruptions. There often seems to be a hope that persistence, or perhaps the sheer novelty of the argument, will somehow carry the day. What is particularly striking is that even if the Magna Carta did directly apply, sovereign citizens tend to overlook the second half of the clause. It says a person may not be imprisoned or deprived of their rights except by lawful judgment of their equals or by the law of the land. In other words, the clause is fundamentally about lawful process. It does not guarantee a lawful judgment of their equals or a jury trial in every case, and it certainly does not prevent a judge from applying Australian law. If anything, it reinforces the idea that legal authority must come from established law. The High Court and other Australian courts have consistently confirmed that modern legislation and constitutional arrangements, not selective readings of medieval text, govern how Australian law operates today. Ultimately, sovereign citizens rely on these and similar pseudo-legal theories to argue that various laws, including taxation, local government, and family law legislation, do not apply to them. The courts have consistently and comprehensively rejected those arguments.
Yeah, I think it's easy to ridicule these ideas, but sovereign citizens seems to be a growing concern in Australia. And for all the reasons we've discussed in this podcast, I think it's an increasing problem and it causes a lot of uncertainty amongst the community and definitely undermines the fabric of our modern society.